As a real estate agent, I'm often asked for referrals to attorneys, but attorneys is a wide range, like of realtors, of different services and practices. And I always say you want to get somebody who is the specialist in the field that you're working in. And while many times people are involved in tangential areas to our business, it's great to find a real estate agent, an attorney who specializes in real estate law. We're excited today to have Jennifer Felten, who is RELAWAPC.com, a firm here in Southern California specializing in real estate law and disputes. Jennifer, thanks for joining us today.
Thanks, Bill, for having me.
So we chatted a little bit beforehand about your background before you got into law. What was it that drove you, if you can share with us, drove you into real estate law as your practice area?
Well, I in my first life, I was an escrow officer. So
Oh my God, they kill you while you're an escrow officer in your first life? I know we get tough with escrow officers, but somebody kill you along the way?
It's a pretty rough life, I will tell you. So I did that for 15 years and then went back to law school. And with that real estate knowledge and expertise, really focused on the real estate aspect. So for the last 15 years, I've had my own real estate law firm focusing on managing people's transactions and disputes and the things that come about with real estate.
So, and then where does your business come from today? You were an escrow officer. I imagine you had a Rolodex of realtors that you were working with. Are real estate agents a significant part of your business?
I get a lot of referrals from real estate agents, whether it's they have issues that they need to deal with or their clients have issues. The real estate professionals, whether it's escrow, title, realtors, lenders, developers, all the people in real estate, when they have issues or their clients do, we're a resource for them.
What's the most common problem somebody calls you with? Because nobody calls you with a solution. Can you file this petition? It's a problem. So what's the most common problem they call you with?
We get a lot of contract disputes, whether it's pre-closing, right, and the buyer and seller are fighting over a deposit, or post-closing and there's some dispute over whether something was properly disclosed or whether there was improper representation. Those are very common issues that come up with us. Or a deal's in the middle of going on and there's a dispute, and how do we handle it? What are the legal remedies that are available to each side?
So oftentimes some of these questions are relatively simple, and somebody might be hesitant to engage an attorney and pay fees and things like that. At what point should somebody give a call to an attorney to get an answer versus assuming the wrong answer and finding out they should have hired you 6 months ago and now they're in a full-blown problem?
Well, I will say, at least with us, we do free consultations. So if you have a simple question, feel free to give us a call and we'll talk through the issue and see if we can give you the basics, what the rules are, how something works. What you read on the internet, what is true, are often the same thing. So
no way.
I know.
No way, really?
I know this is shocking. But I often get people and they're like, well, Google said, or my friend who knows an attorney said, right? So it does not hurt to pick up the phone or send an email and say, I have this issue. This is where I'm coming at it from. Am I in the right place or not? And we're glad to give you direction and kind of point you in the right direction. The dispute has to be enough in value for it to be worth it for you, right? To spend the money to hire an attorney. So, I talked about deposit disputes. If we're fighting over $10,000, you should be going to small claims court. I'm not your answer, right? If you're fighting over $100,000, yeah, you may want an attorney helping you out fighting that battle, right? So, it really depends on the case and the situation and what's going on, but getting good data so that you can make an informed decision is always a good plan.
One of the areas that conflicts seem to come up is deposits, right? You mentioned a couple of times, and as a realtor, that seems to be the one that people fight over. Now, I've been in real estate a while, and we went from having forms that included paragraphs on mediation and arbitration to now where we have e-signing programs that default the customer to initial those paragraphs.
Yes.
And if they don't, it's brought to my attention that they skip those on purpose, and then I have to decide what to do at that stage. Did that eliminate these things from being litigated and push them into mediation arbitration? Do people still end up litigating these things? How has that changed, or has that changed the practice as far as deposits?
So if we're talking about residential transactions in
Yeah.
California, most of them are done on California Association of Realtor forms, CAR forms. The CAR form, the mediation provision is automatic. So it is not even a checkbox. It is built into the contracts. And mediation is a process where you go with the other side to a mediator, right? A neutral third party, and you try to compromise, right? It is not a court. No one's going to make a decision. You're going to present your side, they're going to present their side, and you're going to work with the mediator to try to come to a compromise, right? In the CAR contracts, if you do not mediate, right? So if you try to avoid that step and go to arbitration or litigation, you forego your right to attorney's fees. So it's important to try that step and try to work through the problem. If we can get through a mediation, you can save thousands, tens of thousands in costs and resolve the issue, and we move on. Arbitration is an alternative to court. So an arbitrator is going to make a decision, right? You're going to present your case, the other side's going to present their case, and like Solomon and the baby, right? They're going to make a decision as to who gets what. And with the attorney's fees rules, whoever wins gets their attorney's fees as well, right? So arbitration is not mandatory. It is a checkbox, and it's a decision you should actually be actively making, not just following the contract and checking it off. Because if we agree to arbitration, it means you cannot go to court. You waived your court rights, except for very limited circumstances like small claims court or unlawful detainers. Aside from those, we're in arbitration. Arbitration is quicker and simpler, but it can actually be more expensive because you got to pay attorneys and an arbitrator, right? Whereas a judge, when you're in the court system, you pay a filing fee, but that's it. With an arbitrator, you're charging $500 to $1,000 an hour for an arbitrator to look at your case and make decisions and decide. And whereas in court, if they do it wrong, there's an appeal and a process to deal with it. In arbitration, the arbitrator's decision goes. Unless there was bad faith or some sort of malfeasance, even if they didn't follow the law, their ruling stands. So I don't love arbitration. I recommend against it. I would not initial the arbitration clause in a contract, but we arbitrate, right? If people have done it, that's the process, and that's what we do.
It seems to me, and I'm not here to disparage the entire industry of arbitrators, but in general, my experience, having been in them as a witness or as a party, it seems the arbitrator is glad to have the arbitration go on, and the one feeling you always feel with a judge is they want the thing resolved. It's like there's a train going downhill, and he's in front of it or she's in front of it, and they want this thing resolved. And so you feel this constant pressure to settle, constant pressure to compromise, constant pressure to avoid the hearing that's going to cost a fortune. Whereas arbitration, it's in a nice office, and they're pleasant, and there's coffee, and there's like a receptionist, and next thing you know, you're there for 4, 5, 6, 8 hours, and then you have to come back another 2 or 3 days. Sometimes it does not feel like it's going to work for the customer. So interesting to hear you. I've never had anybody say that they would avoid arbitration. I think as a business person, I think I would agree with that assessment, but as a broker, we have some kind of limits as to what we can do and can't do. Let me ask you that question. I mean, you're obviously not going to advise me as a agent, and I work for brokerage, eXp Realty, where we have a managing broker and we have attorneys that advise us theoretically. But as a general rule, do you advise agents to pass on that advice as far as the arbitration, that it would be advantageous to the customer not to select arbitration in a general, let's say semi-standard, if there's such a thing, residential transaction?
I think it's something that you should at least advise them what they're doing, right?
Mm-hmm.
That's what the role of the realtor is to give them information, not to give them legal advice or help them make the decision. So you can say, this is an arbitration clause. This is what this means. It means if this goes to a dispute, you're going to be in front of an arbitrator instead of a judge. You're going to lose some rights, but you're going to gain time and money, right? Like, so giving them the pluses and minuses, like a list, just like we do with vesting, for example, right? If someone says, how should I take title? You should not be advising them on how to take title. You should say, here's a list of how this works, and you need to make this decision, or get an attorney to advise you if it really is a big deal, if you're really worried about it. But being a source of information and understanding the difference, really important for the agent.
Yeah. It always surprises me. I was involved in a transaction with one of the largest offices in the area, where I was having a discussion with the broker because the agent wasn't able to, he kind of got emotional and the whole thing fell apart it was about the deposit area.
Yeah.
And even the broker apparently didn't know what the basic default wording was of the contract. And I always feel like the number one fallacy or shortcoming of most real estate agents is they're not even reading the forms they're having customers sign. How is that something in your practice? Let me back up. What's the number one mistake that you see real estate agents make in their business that causes conflicts that have to come to your desk to get resolved or get advised on?
The biggest issue where the real estate agents are involved are disclosure issues, right? Of getting the right information to the consumer relative to the property. Or if you don't have right information, letting them know, this is what I have, you should investigate and find out more. So a real world example, I had a property that the buyers came to me after they'd closed escrow. This was during COVID, and we were in this, the houses were getting 50 offers on them, this high multiple offer situation. This was a house in the hills here in Calabasas.
Oops.
Like already just that alone is like, uh-oh, right? So,
was it fire or cracks in the foundation with the problem?
It was the foundation.
There you go.
And ADU that was built in the back.
Oops.
So the foundation was crumbling under this house, and an ADU had been built in the back that was not permitted for living space, and it had a septic tank, which we didn't do a septic inspection for. That when they actually did inspect later, found out that the septic tank was actually a trash can with a pipe to it in the backyard. So
it sounds like a problem. I'm not an expert on septics, but it sounds like a problem to me.
That's not a septic tank. So, but in this case, because of the market we were in, the agent told the buyer not to do inspections, right? They said, if you ask for inspections, you're not going to get this house. So this buyer bought this house, and none of these inspections and none of this research was done prior to close of escrow. We were looking at over $100,000 in repairs to bring this property to code and manage the issues. The fact that the buyer should have entered or could have entered into a non-contingent offer is one thing, right? So they probably wouldn't have gotten that house if they had contingencies. But just because you don't ask for contingencies doesn't mean you don't do your inspections.
Right.
The CAR forms totally allow you to do inspections even if you have zero contingencies. Right. So proper advice to this consumer would have been, if you really want this house, a non-contingent offer makes sense, but you should still do your inspections, because they would have found out that there's $100,000 of repairs, and they could have backed out. If they backed out, they might have lost their deposit because it was non-contingent, but they would have lost their deposit, not bought a house that they now have to put $100,000 into, right?
Well, and also I think sometimes if they discover things, there might be a way to not lose your deposit, right? Because perhaps they make a mistake and issue a disclosure later that's inaccurate that you can use as your base and say, it's not contingent, but you're not allowed to lie. And we caught this as being inaccurate. Again, legal, I'm not sure where that falls out, but I know that the threat of that's enough to get people's attention, where especially market with multiple offers, they just assume sell to somebody else and not bother with you. Then if you have a possible cause of action, pursue that with you and force you to buy it.
There's a whole bunch of different things that could have happened if they'd done their inspections, right? They could have negotiated. I mean, in this case, part of my issue with this case and why it was a problem was the seller didn't know that about the septic, like that issue. the seller didn't know. That had been built by the prior owner. So
Right.
they lived with it not knowing it was
Right.
bad. So it wasn't a failure to disclose because they didn't know.
Right.
And the foundation, if you went into the house and you put a ball down on the ground, which everybody knew because they told me this story, if you put a ball down on the ground, it would roll, which meant the foundation was not solid, right? So it's very hard for a buyer to say, I knew there was a problem with the foundation. I didn't do inspections. It's your fault, right?
Right.
So, but it also, if the inspections had been done and they see this $100,000 in issues, the seller now has to disclose all this to anyone.
Exactly. Exactly.
Right? Working with this buyer and making a deal is probably still a better option, right?
Because you make sure you send every report to the listing agent, every single defect.
Correct.
And then you can come back and they'll say, well, you have any contingencies? Well, yeah, we could walk from our deposit of 10,000, but now you have to remarket it with all these discrepancies. And by the way, I'm going to check the MLS and make sure they're noted, and I'll see who closes. I'll make sure I reach out to them, make sure they know about that, because I don't want to fraud a fellow real estate agent. So I think that's definitely an opportunity where you have the leverage and just communication. So failure to disclose, in this case, is really failure to take advantage of inspections. I do agree with you that just because you don't have any contingencies is not a reason not to do inspections. In fact, the opposite, all the more reason.
Right.
I would say the opposite, all the more reason to do every possible inspection,
right.
so that you know exactly what you're getting and possibly can use as leverage against the agent. So that's the biggest mistake that you said you see agents make, and I see that one. What are the biggest mistakes you see sellers in transactions make when they sell property?
I think it really goes to kind of those same concepts of what they know about the property and making sure it's properly conveyed. So another real case, I have a buyer who bought a house in Camarillo in a decent neighborhood, from what I can tell, or they thought it was a decent neighborhood. There's no disclosure about any issues to the neighborhood from the agents or from the seller. But so they close escrow. The day they move in, the seller had left like a telephone register of like all the neighbors. So it had the names of the neighbors and their phone number, right? So this is a community where the neighbors are actually talking and friendly. But on the list, there's a picture of the next door house, and then there's a little handwritten emoji with a frowny face, and it says drug house. The house next door is a drug house, and people are selling drugs out of the house. So since my clients have lived there, people have driven onto their lawn. Druggies have showed up at their door thinking they were the drug house, right? The seller can't say they didn't know. They gave them a sheet with a picture it says drug house, no disclosure of the issue with the neighborhood.
Wow.
Right? So disclosures as to sound, right? I have a case where it's a condo and the neighbor upstairs had replaced their carpet with wood floors, and the noise in this unit is just horrendous, was not disclosed to the buyer, right? If there's been some sort of tragedy, a murder, things in the neighborhood, those need to be disclosed, because you think you're not telling them. Well, the neighbor who shows up the day they move in and says, I'm shocked you bought this house. Did you know that, grandma was murdered in the backyard, right? Like these are real cases I have. Right?
People love to tell the new buyers. It's just, they're going to find out. What's interesting to me is I do mostly probate real estate. So my client oftentimes has never been to the property, knows nothing about it. And, you try to disclose what you can, but sometimes you don't know what you don't know. And then inevitably the buyer goes to the house and it's the first person seeing it in a while. And the neighbors come out. And I want to hand them out disclosure forms. Can you just put everything you know here and sign this? I'll give it to the buyer. I keep a copy because they know more than I do.
Correct. Well, and so it's really about communication. And it's not a simple answer, because one of the issues with disclosure is that the California law is very favorable to the buyer on this issue. You have to disclose anything the buyer would consider material. Well, so you got to get into the head of the buyer and figure out what's important to them as to whether this is an issue or not. So I have a property it's in Studio City. They were in escrow, and the alarms on the house went off, right? So, and no one, it's an empty property. No one's living in the property, but something set off the alarms. And we gave notice to the buyer, and they canceled that the alarms went off. It made them feel like the property was unsafe or someone was targeting it or something like that. Like it wouldn't have freaked me out that an alarm went off. My office alarm goes off every couple months, right? Some random thing, right? To me, it's immaterial, but to this buyer, it was a huge deal. So that's part of the challenge is you don't know what the buyer's going to think is important or not. And often you find out after close of escrow that what you didn't disclose because you didn't realize was a really big deal to them. So, my recommendation for sellers is anything you can think of, disclose. They're going to get piles of paper this high of all this stuff. The chance of them canceling over something you disclose is really low. But if they do, I'd rather them cancel than sue me after they close over that issue, right?
Interesting. So I live a block and a half from Pico Boulevard. I live in a really nice neighborhood, very walkable, but we have the occasional people who just walk down our street and knock on our door. Maybe they're casing the place. Sometimes they're just looking for money. They're looking for food. They're looking to see what's there. How much of that do you disclose, right? Because to me, that's part of you live in a block and a half from Pico. That's why we have fences, gates, alarms, cameras, lights, and all that. But to a buyer, they may not be aware that that's kind of what life is like in Los Angeles today. It wasn't that way 10 years ago, but that's how it is today.
Right.
So you disclose that? You disclose that you have victims that come to your house occasionally?
Absolutely.
Ooh.
Yeah.
I'd be writing a book if I had to sell this place. Wow, that's no good. Okay, so I know that relator part of real estate law, as you mentioned before, is probate and estates, things like that. People have houses that somebody wasn't living in, vacant properties. We've had, one of the recent topics that is more discussed now in real estate is the term we're using is squatters. I would say grand theft house. You have people who are basically stealing the use of a home or stealing the home. It seems that more and more, for example, in commercial real estate, we used to put signs up when we had vacancies. Now we purposely don't put signs up with vacancies because then we don't put up before the vacancy because the tenant leaving doesn't want to get robbed because there's like these criminal elements that are so intense now. Are you seeing an increase in these types of challenges? And then what, if anything, are you advising your clients to protect themselves?
Yeah, there's a lot of issues with occupancy, whether it's even a lawful tenant, an unlawful tenant, right? A family member living in a probate house and trying to get them out, right? Mom let the wayward son live with her, and now he thinks he gets to live there rent-free for the rest of his life, right? All these types of things come up. So getting the proper representation to manage these things is really the answer. And the system is very favorable to the occupant, not to the owner. So
no, really?
But so just know it's going to take time and money. We do not do unlawful detainers. That's just not our space. But I'm fully aware of kind of the world that is out there with that. It really is getting the right documentation, getting the right disclosures. There is a way that if you're going to have your property vacant, that you can notify the local police department that it is vacant. That way, then if someone does squat in the house, they will come and remove them. Oh. So there are processes and procedures that can manage some of this stuff, but you got to get the right people who know about it to help guide you to do it.
So I'm always encouraged when I hear an attorney, like you say, or any professional, I do this, I don't do that, because I think particularly with unlawful detainer, you really need a specialist that knows that city's ordinances and that particular procedure. I think there's certain things you can always do as an attorney that are general. I advise now attorneys from a business point of view, not legal, but just from a business, if we have the wayward son and he says he's vacating, let's send in the 60-day notice now, just so we start the clock. Do it in a non-confrontational way. Hey, the attorney made me do this. I'm really sorry. I feel bad. The terrible attorney, Jennifer, made me notify you. But at least now the clock started versus we find out day 59 or 61, do we have a problem and start the clock then? And now we have a contract and a buyer and all that going on. So these are issues where it's good. So is there a particular attorney that you refer that work to, or is there a group of attorneys, or how do you, if I come to you and I'm a family, we have a vacant home, we need some legal action, how do you handle that?
It depends on where you're at and what the issue is. So we work with other attorneys on all kinds of different things. So we have a database, and depending upon what your issue is, where you're at, right? So we have if tenants come to us, we have a list of attorneys that work with tenants versus landlords versus, right? Whatever the different issue is, making sure that you're getting someone who is an expert in that area, because, in California, with the amount and scope of laws and the issues that we deal with, being a specialist is a necessity. If you're trying to be a generalist, you're gonna make mistakes.
Well, I think it's, if I was advising attorneys, not that you're asking for my advice, but business-wise, for sure you're going to make more money and be more valuable to your customers by specializing, because you're going to go deeper in something, and that means you have to get rid of the surface area in another. I will add one piece of information. I don't know if you've ever been to the court where they do the unlawful detainers.
Mm-hmm.
At Moscow, it's on the 6th floor, and I've been to other courthouses. I don't think you can get inside a tenant courthouse, a dispute courthouse, without being solicited by at least one free legal service. I think it's physically impossible today. There's so much legal help to tenants, and encouraging them, even those who are walking in to avoid, a judgment and want to make up a bad payment, but can't. For even legitimate, the 1% are legitimate, I don't believe they can get in the courtroom without being solicited at least once. I just think it's mathematically impossible.
Well, there's money out there from the government to support that side of the process.
Right.
So yes, but look, there's a balance to all this. We want the tenants who deserve protection to get it, right? And there should be a system for that, but it shouldn't be at the cost of a landlord who hasn't done anything wrong, right? So there's a balance somewhere in there.
I think you're being completely correct. I've not met a tenant who is being treated unfairly in so long. I used to have them call me from time to time, and because you're in real estate, if you think you can help. I agree with you, there has to be a balance. I agree there's bad actors in every business, but I think we've swung so far on that one that it's just a personal point of view, or maybe it's my experience as not representative. But okay, so last question, I guess. I know that in the course of your business, you get business from real estate agents, you work with them. What would you say the best practices of the best agents you see that you think make them successful, or what do you think are the one or two challenges you see, the ones that struggle, that they should avoid?
Well, I think the biggest thing for a real estate agent to be successful is to run their business. They're small business owners, so they have to know that, right? Not all of them realize that. You're a small business owner, and get the right support systems and build the right schedule management. Like, you need to work it like a job. It is not a pastime. It's a job. And, whatever your schedule is, your 8 to 10 hours a day, you're working. You're not thinking about what I might do later, right? Or, and whatever your marketing system is, whether it's cold calling or social media, whatever it is, you need to be committing a certain number of hours a day to marketing. You need to be committing a certain number of hours a day to production, right? A certain number of hours of days to managing. That's what I do as a small business owner, right? I market 2 to 3 hours a day. That's how I'm able to build the pipeline to support my team. And that has to be part of my schedule every day. It has to be planned. And then the production work that I have to do has to be planned. So you need to run and be a business. This is not, the successful ones get that and do that. And then as they grow, they build the team to support them. Because this is the thing, none of us is an expert at every skill set that is involved in what we do. I'm a really good marketer, rainmaker. I'm not a great people person with my staff, so I have someone else manage my staff. That's not my skill set, right? So building the right team. If you're great with sellers, hire a buyer's agent to support you and work on that side of the business, right? If you're the salesman and you're the talker and you're the one who should be out there, you shouldn't be sitting around filling out forms and, checklists. Hire a transaction coordinator, get the right team to support you with that. But this is a business. The ones who don't take that seriously and who don't value their time, you should figure out that you should sit for a couple of days and look at what you do all day long. And is that the highest and best use of your time? Or could you hire someone for a significantly lower rate to do that thing so that you could be doing something else that is productive? So I don't clean my house. I hire someone to clean my house so that on the weekends I'm spending time with my kids and doing what I value versus mopping the floor and doing laundry, right? So those are the skill sets, and learning that and balancing that is how you're going to build a business and brand and be successful in any enterprise, law, real estate, whatever.
100%. Unless you enjoy mopping the floor. I mean, there are people who, it was interesting. I was watching a video on productivity techniques of top Japanese businessmen. And one of their big things, I've never done it, I would never do it, is clean the toilet every day.
Interesting.
And because there's a certain feng shui to that, and in their religion. And okay, I get that's, and if you get the pleasure from that, good for you. But unless you do, and you can pay somebody a 1/10 of your hourly rate to do that work, it frees you up to do the work that's worth more valuable. I couldn't agree more. Well, Jennifer, great business advice, great legal advice for somebody who wants to give you a call and maybe run by a real estate law challenge of sorts to see if it's a bigger problem, or if they know they have a big problem and need to get some help. The best place we have is RELAWAPC.com. RELAWAPC.com. We'll have that description. On there, there's a contact button. There's also a phone number you can click. There's a video you can watch. Is that the best way to get a hold of you?
Yes, the website's the easiest way, or any of my social media channels. Jennifer Felten with an E-N, T-E-N. I'm on YouTube, LinkedIn, and Facebook.
Fantastic. Jennifer, thank you so much for your time. I really appreciate it.
Great. Thanks, Bill.